Okay, hi everybody. Happy Friday. There has not been any testimony in the Karen Reed trial since Wednesday, but we still wanted to do a Friday recap just to go over everything that's happened this week. So, hi, Catherine.
Hello there. Nice
Hi.
to see you.
Okay, I want to start today with something that might be mundane, but
Sure.
I make the mistake of reading internet comments. And people are very concerned about the scheduling in this case and the
Okay.
fact that Thursday was supposed to be a half day and it got canceled. And now there's no court Thursday, Friday, and then obviously Monday's the holiday. Next Thursday's a half day. Um, my understanding, and just based on our reporting, is that the Commonwealth only has one more witness to call, and that's
Right.
who has to fly in to testify. So I believe that may be playing a role. But can you talk about like, is this scheduling unusual? There's a lot of allegations that it's like laziness at play here.
No, no. And often oftentimes on the front end, to me, most of the days, the half days, the days off, and we really haven't had that many compared to trial number one,
Right.
seem to all be pre-planned for the most part. Even the fact that they were supposed to have a half a day on Thursday, when you think about what goes into sort of that evaluation as the parties in the court is, all right, if you only have this one witness left, they're definitely going to be longer than the morning, right? So likely, I expect Dr. Welcher to be at least 2 days, I would think. So what is the sense in having him fly in for 3 hours in the morning on Thursday, sending him home on a flight back, only to come back Tuesday? That's one of those things that collectively all the parties and the judge come together and say, doesn't this strategically just make the most sense to give everybody the break? The jurors already have Friday off because it's Memorial Day weekend. I mean, that's pretty generally the courts are considerate of people's schedules. When you're asking people to sit on a jury trial for months and months and months, a lot of people do have plans, especially around here in Massachusetts, going away for the weekend, Memorial Day. And so to cut it short a little bit on the Thursday because of the specific witness issues is not unusual. It sounds like next week has already been planned as a half a day for quite some time. So that's likely due to somebody's scheduling, whether it's the court, whether it's one of the attorneys. There's obviously something that was sort of factored in. So it's very normal for them to take into consideration all of these scheduling issues, particularly when it's a trial that lasts this long.
Right. And just so everybody knows, scheduling going forward, there's no court on Monday because it's Memorial Day. And then there's a
Right.
full day Tuesday, a full day Wednesday, a half day Thursday, and a full day Friday. Um,
Correct.
okay, the next topic I want to move into is the rest of the prosecution's case. Um, we've talked a lot about how this has been a very different case they've put on from the last time. A lot of witnesses have not been called. Actually, if I check my notes, they've called 37 witnesses. So if Dr. Judson Welcher, who's a crash reconstruction expert, really is the last witness, that'd be 38 witnesses compared to 68 last trial, if I remember correctly.
It's a lot. It's a big difference.
Huge difference.
Big difference.
So if Judson Welcher, just so everybody knows, he's a crash reconstruction expert for a company called Aperture. The defense tried to get him excluded from trial at one point unsuccessfully, and he, we believe, is the last witness for the Commonwealth. So for the Commonwealth's case and what's left, what do they need from him?
So they need him to sort of explain what the Commonwealth actually thinks happened. And it's not that without it, the jury couldn't reach a conclusion potentially that the Commonwealth has already proven beyond a reasonable doubt. Because remember, there's different kinds of evidence. We have, circumstantial evidence. We have direct evidence. In this case, we don't have any. We don't have witness testimony that Karen Reed has backed up into John O'Keefe. We don't
Right.
have video that Karen Reed has backed up into John O'Keefe. So what we do have from the Commonwealth's case is, all of these different pieces of physical evidence, of witness testimony that leads the Commonwealth wants the jury to lead to the place of there's only one option, and that's that Karen Reed hit John O'Keefe with the vehicle. But this really theoretically should tie up what they actually believe. I don't know if we're going to have some sort of, 3D reconstruction or some other sort of, physical reenactment using an actual Lexus. When we don't know what we're going to see, I'm sure there's going to be something. But what from the Commonwealth's perspective, what Dr. Welcher needs to do is tie together sort of all the data points in the moment of what they believe is the collision. And, then what that leaves the jury with, I'm sorry, is all of these, you think about, sometimes we think about when we watch criminal trials and the difference about the expectations versus what reality is in court in the law, that there's going to be this big smoking gun. I don't
Right.
know that Dr. Welcher is going to, you know, he's going to solve it and wrap it up and aha, that's it. What he does is provide more sort of context and in-depth analysis about what they think more specifically could happen, but it ultimately still requires the jury to evaluate all the evidence as a whole, including Dr. Welch's testimony, and say, okay, all these pieces of evidence, does that show us that Karen Reed hit John O'Keefe?
Yeah, and let's put aside all of the external kind of moments like the drinking and the fighting and all of that, and just focusing in on the alleged crash. The fact that the
Right.
Commonwealth says Karen Reed backed her car up into John O'Keefe. Last trial, there was a very, I think maybe nobody would disagree, like a wonky presentation of what happened. They had Trooper Joe Paul on the stand, who's a really nervous witness. There was testimony about like the car hitting his arm and him doing a pirouette and being thrown back 30 feet. Does it seem to you, especially after hearing the neurosurgeon testify about the back of the head, does it seem like the actual theory of the alleged hit is different this time?
I mean, it seems, my guess would be that the theory is there's some sort of clipping of
Okay.
John, which, given the given what the injuries look like, it that seems to be the more realistic. If that's what actually happened, it seems to be the more realistic theory than a full blown impact, either front of body or back of body, because I think people's questions about his injuries not being consistent with a traditional motor vehicle strike are fair. And
Mm.
the question is whether, if you sort of, if you think about, if you kind of clip somebody and knocked them off balance and then the fall back, that seems to at least be more of a realistic theory than, he was just completely backed into and run over. And, the interesting thing is, I don't know that they have to, you know, the reality is we nobody knows, right?
Nobody.
The best that ARCA can do, the best that Aperture can do, is say that based on the information that we have here at the scene, all of the physical evidence, all of the witness testimony about how he was found, where he was found, what the data points are, they basically bring all these points together and they say, this is what we think is the most likely cause of his injuries, but they can't say one way or the other. So that's really ultimately a question for the jury, is that, do they find the Commonwealth's presentation to be sufficient to say that, yes, Karen Reed did this?
Do you think Judson Welcher will try to answer the question of how a taillight could smash like that?
I think he probably has to.
Yeah,
I
but I'm not
think
sure
he
that happened, right?
right, right. I think he has to. And that's one of those, I mean, that is one of those questions that, as a lay person, what does it take to break a tail light like that? Is it unlikely, or is it unusual for, if you clip someone, to be able to break it like that? Probably. Is it impossible? Likely not. But we need to hear from somebody who actually knows and has, they have all of these witnesses, Aperture and then subsequently AGA, they understand, um, based on their expertise of having tested crashes in different scenarios, what is possible and what's not. So I do think we have to hear about physically how it could have happened.
Yeah. Um, okay, the next thing I want to get into is okay, here's where we're going to get granular that we don't have time to do on TV. Let's talk about the taillight pieces in the glass that were tested.
Yeah.
So, State Police Crime Lab, I can't remember if she's a chemist or what her actual job is, but Christina Hanley, she works with State Police Crime Lab. She
Right.
tested the plastic from the taillight and the glass found on John's bumper, the cocktail glass found next to him, and also glass found on the ground.
Right.
Um, and the taillight pieces, I think we can just get out of the way, right? She tested tiny pieces of taillight that were found in John's sleeve that she said,
Right.
I'm calling them pieces of taillight because she said they matched the taillight.
Right. Right.
basically.
Correct. That's correct.
Okay. The glass, the whole presentation, I think, was probably a little confusing
It
for
was.
people because
I
I
mean,
think everything is a number rather than an item.
right. And Jackson, and it's really interesting because it was virtually the same thing as trial number one. And
Yeah.
this was an issue that was very confusing trial number one. So it's surprising to me that there was no change really in the presentation of it. Because, even when Alan Jackson got up and said, okay, can we just like break this piece is this and this piece is
Yeah.
right. When you're trying to impress upon a jury a piece of information, you have to make it digestible for them.
Right.
So, you know, even though even though we watched this whole trial, the first trial, and we watched this the second trial, I still came away with it being like, I'm not quite sure what was the testimony. So some of it matched, it wasn't a physical match. Questions like, to me, the real question should be, okay, when you say it's not a physical match, do you mean that you don't have all the pieces of the puzzle so you can't physically match it together, but it's
Right.
the
Do you mean
same
they're not the same?
consistency? Or do we mean they're not the same? And
Right.
that wasn't, I don't think, I mean, I would see what you think, but I don't think that was made clear at all. And
No,
then
and
what it does is it just leaves more questions than answers, which is
right. And
not what you want if you're the Commonwealth.
I had to go back and rewatch the testimony twice, and to the point where I was writing down the item numbers, like 7
Right.
12,
And,
7
and the
14.
jurors are not going to be
They
doing
can't do
that.
they can't
Right.
do they
Right.
can't go back and rewatch testimony.
Right.
But I tried to do it mainly so that my story made sense when we were
Right.
writing it. And what I believe the takeaway was, at least from the defense's case, was that the cocktail glass found near John matched some of the glass found in the roadway,
Right.
but didn't match the glass found on Karen Reed's bumper.
Right. Right.
The glass found on Karen Reed's bumper matched one piece of glass in the road found by Trooper Proctor.
Right.
What is the jury supposed to take from
I,
that?
I, to be honest, I don't really know. I
And
don't
what
really
is
know
the glass
which way,
for?
one way or the other. Right. Where did the other glass come from?
Right.
And there's this is the funny thing is, obviously, as we know about this case, is that there's so much, extraneous information that, we're trying to think, oh, did it come from the glass that Karen said he took out of the car? Did he have two glasses, things like that? But I don't
Right.
think that's in evidence, number one.
No.
And number two, that's not something that the jury is picking up on. So if you're a juror, I think to be honest, I think it's so confusing that you might just take it off the table completely. It might be a wash,
You might just not even
if
consider it.
right, because if you don't even know which way you're supposed to interpret it, then you sort of take it off the table for consideration, I think.
I know. And I mean, do you wonder, like in closings, will anybody try and clarify that? Because it really was
I
interesting.
well, and that's what, the strange thing about the way that was presented in, because if from the Commonwealth's perspective, if it would be a physical match if they had all the pieces, then that is a strong piece of evidence. But if you don't make that clear to the jury, and then you give the defense the opportunity to rebut it with like, what are all these other pieces of glasses? Then I don't know. I don't know that it's worth clarifying in closing, because I think it just complicates things more.
Okay, and for us and for people who kind of obsessively watch this trial who aren't the jury, um, I'm trying to put this all together. So we know there's surveillance video of John O'Keefe leaving the waterfall with a glass in his hand.
Right.
Um, and then also there's an interview clip where Karen Reed says they left CF McCarthy's and he had her take her glass of vodka soda with her.
Right.
So is there a chance there are two glasses in that car?
Well, I think there could be. The problem is the connection again, because unless they really draw it in and point this out to the jury in closing. But I don't know that, again, when we're watching it, and we know because we've seen these videos before, so we know, what John has in his hand, what Karen says. My question is, are the jurors, in the moment those things are being played in court, are they picking up on, I should be paying attention to the glass or what's in his hand? I don't know that they are. So I think it's one of those, I think it's one of those issues that just complicates things either way. Could it be two glasses?
Yeah.
Maybe. The problem, at least from the Commonwealth's perspective, because it's their burden, is that what that requires is sort of more speculation. And you just want the jury to focus on like what we think we can prove to you. We
Right,
don't
right, right.
want you to say, oh, maybe it could be this, maybe it could be that, because once you start speculating, then you start speculating about everything.
Right, right. Okay, I'll switch gears now. I'm not sure we clarified anything, but we
No,
did how confusing it was.
we try.
Um, Dr. Wolf, who testified, he's a neurosurgeon from Miami, testified for the Commonwealth. This is not Dr. Wolf, who's testifying for the defense. There's two of them. Um, you said in our conversation earlier this week that he was quite a strong witness for the Commonwealth, and he had a very, very short cross-examination. So what he testified to was essentially that, in his opinion, the only way John O'Keefe could get the injuries to the back of his head, his brain, and even his eyes, except for a cut on his eye, was the result of falling backwards, and he said on cold, solid ground.
Right.
Um, why do you think, I've been reflecting on this, why do you think the defense didn't ask him if it was possible that that fall could have happened anywhere else, given their theory that John O'Keefe went in the house?
Well, I think that it comes down a little bit. I mean, I've thought about that too, that, or, could it have been, because of a punch or things like that. And he did speak at his direct examination. He talked about, a fight, or when people have a heart attack, when they're snow blowing and fall straight backwards, things like that. Sometimes well, not sometimes. One of the rules of cross-examination is don't ask a witness a question that you don't know the answer to.
Okay.
And so it's easier, I think, in argument, maybe in closing an argument, to make to talk about, he gave them a little bit of, it could have been because of a fight, things like that. You don't want him to, if you say to him, could it have been anywhere but cold, hard ground? And what if he
What
says
if he
no?
doesn't? Right.
Right. Right. So you don't want to even open up the possibility of that. So you take what you can from him, because he's such a strong witness. He's a neurosurgeon. He talked about his certain 4 brain surgeries the next day, full of patients today on Friday. And, the fact that really that less than 1%, he said, was of his business was expert witness testimony. So this isn't somebody who, like Aperture, like ACA, maybe like a potentially the neuropathologist, people who testify as a business. It's how they make money.
Yeah.
So I think he had that sort of extra layer of credibility. So
Yeah.
if he says no to the question that you need him to say yes to, you have a problem. So better thing to do is just don't ask the question.
Okay. The final topic we have to get to, which took up the most time this week, is Shannon Burgess from
Mm.
Aperture. So, for anybody who either didn't watch or doesn't remember, Shannon Burgess works for Aperture, the same company that the crash reconstruction expert who has yet to testify works for. And he did studies based on a chip that had been previously undiscovered inside of Karen Reed's car, which he says basically revealed the time of several times Karen Reed's car turned on and off. So he did this whole presentation showing, like, see, her car turns on at this time, and here's a surveillance video showing it. Her car turns up at this time, here's a surveillance video showing it. All to get to the point where he says the Karen Reed's car backing in reverse incident happened and ends sometime, I hate that I have this memorized, between 12:32:04 and 12:32:12 a.m.
Yeah.
Um, then he's kind of dismantled on Cross.
That he
What?
was.
Yeah, I mean, he was dismantled on his credentials were incorrect. He had had multiple resumes that falsely stated he had finished college when he hadn't. His timeline on his PowerPoint was actually written incorrectly and was a full 24 hours ahead of when the events in question actually happened. Is the jury going to take him seriously?
Um, Maybe, but also strong likelihood that maybe not, right? And because when you two things can be true at the same time. His interpretation or analysis of the data could potentially be accurate,
Yeah,
and he also has credibility problems. And
right.
so ultimately, as with all other pieces of evidence, the jury decides, how much do we weigh it? Do we, value his opinion, but then question it so significantly because of the mistakes that were made? Because, like you said, it's not just, it's twofold. It's the credentials, which, and understanding that he didn't submit incorrect credentials in this case,
Right.
and the Commonwealth tried to rehabilitate him about kind of how his CV ended up like that on Aperture and things like that. But either way, this idea that you would put anywhere that you had a bachelor's degree when you didn't, I mean, that's a pretty big problem. You know what I mean? That's not a minor mistake. And then on top of it, when there's sort of sloppy errors like putting January 30th on the timeline when it's January 29th,
Yeah.
so ultimately it goes to whether, the jury could completely dismiss him based on whether they find him unreliable, or what they could do is look at the data. And I think it's interesting in this case in particular, because if he was the only person presenting the data, I think it would be probably they would dismiss it.
Yeah.
The problem for the defense and to the benefit of the Commonwealth is that you have other witnesses who have testified to this data. So you have Ian Whiffen, you have Jessica Hyde, you
Right.
also have the videos that we saw, lining up with the other data. So it's difficult to, and especially when we're not talking about hours here, we're talking about seconds.
Second.
So theoretically, even if he's off by seconds, we're only talking about seconds, right? It's not like he's saying it happened at 4 p.m. and it actually happened at 4 a.m. We're talking about, the numbers that now I forget, 12:30, 2:04.
Right. Yes.
Right.
12:32:04 to 12:32:12.
Right. So I mean that's 8 seconds. So
Yeah.
then what the jury does is I think if they say, all right, we have problems with his credibility, but like let's look at the data. And is there anything else to support his interpretation of the data? And we have the videos, we have Whiff and Hyde. And then theoretically, with Dr. Welcher testifying next week, who's supposed to basically buttress Burgess's testimony, they might not dismiss it. But again, that's one of those things that it really it's why the jury system is so unique, because people do interpret things different ways. So just like
Right.
we see online, and we all look at one set of information and we get two different analysis. I might be somebody who says, okay, yep, I have a problem with the resume stuff, but I do find him to be, proficient in his analysis. So I do credit. Somebody else might say, hey, if you lie about that, I can't trust anything you're saying. And that's what happens in the jury room, is that,
Right.
there'll probably be some of both, to be totally honest.
So my last question about him kind of for you is, are his credibility issues going to impact Dr. Judson Welcher's testimony? If he is supposed to be this like ace for the Commonwealth who recreates the whole crash to explain things, did Shannon Burgess taint that?
I mean, the goal of the defense will definitely be to make it seem that way, for sure. The question is whether Dr. Walcher, I mean, basically, he has to, when he gets up and testifies, he has to basically say, I looked at, based on the review of all the evidence and the data from Burgess, as well as everything that I reviewed in addition to that, I think his interpretation is valid, and I adopt that interpretation because I've independently reviewed everything, which, we don't know what the process for Aperture is. I don't know whether, when Burgess does his analysis, if Welcher is supposed to, check it, confirm it, if he just accepts it as truth. So that's a real area of cross-examination, that I think can be beneficial to the defense, because theoretically, if their internal process by which, like, ultimately the reconstructionist reviews all the data from the an analyst underneath, if they don't independently confirm that data, then you can say, well, you have to throw Welcher's opinion away because he had bad data underneath. But I mean, that's definitely open for cross-examination.
All right. So moving forward, we believe Judson Welcher is the next witness and possibly the last witness for the Commonwealth. Catherine and I plan to do a pretty in-depth recap of the state's whole case once it's finished before the defense's case starts. So look out for that. And we'll also see you next Friday.
That's right.
Hey, before then.
And everybody have a wonderful Memorial Day weekend. And hopefully the rain
Well,
has cleared where I am. So I'm just
it
hoping
has
that maybe we hold off, maybe we'll get, a little sun before
not summer,
Tuesday.
but it'll do.
Yeah, we'll take it.
Bye. Thank you.
Bye. Thanks.